Hello everybody, welcome to iExamBee's LegalBee. This is Amrita, your law faculty at iExamBee. In this video, we are going to discuss the landmark judgments between 16th of February to 28th of February. ये एक बहुत ही इनोवेटिव और बेनिफिशियल सीरीज है जो हमने स्टार्ट की है at LegalBee from the month of January 2023. Every 15 days, we are getting you a video. Very next day, that is the very 16th day, we come up with all the recent landmark judgments that have been passed by the Honorable Supreme Court of India and various high courts, which are really landmark and important. We are the most prompt to get you these judgments the very 16th day, I repeat, क्योंकि हर 15 days का compilation हम आपको देते हैं. Along with this, we are also giving you PDF. You can download it. You can also download the PPT. Why this is so much beneficial for you? This is very beneficial for you for all the examinations that you are preparing for, in which you have legal subject in the form of legal GK, in the form of constitution, or as a main subject UPSC हो या फिर आप judiciary के लिए prepare कर रहे हो. For all these examinations, if you are updated with the very recent judgments, with the exact provisions that we are discussing in these videos, in these PDFs for each judgment, and also the ratio that has been let down on the case. It gives you a lot of insights about the law, the dynamic nature of law that is going on. And also, if you are a practicing lawyer, if you are an academician, if you are a lawyer, if you are a law school teacher, if you are a law student, आप लोगों के लिए हर discipline में actually ये बहुत ही important है. So please don't forget to subscribe to our YouTube channel and stay updated with such kind of videos that we keep on bringing. इन PDF और PPTs को डाउनलोड करके आप एक रेडी रेफरेंस रख सकते हो आपके पास. You can take out the printouts of these as well to keep a record with you of every 15 days judgments. Let us start with the first one. I am going to discuss with you all the judgments 16th February onwards, 16th to 28th of February, जो landmark है, जो कुछ important है, important contribution दे रहे हैं, that we will be discussing. First, starting with the judgments of Supreme Court, Honorable Supreme Court of India. Suresh Kumar, Lalit Kumar Patel and others versus State of Gujarat and others. It is a special leave to appeal that has been filed. In this case, actually, the decision to reduce the cutoff is not based upon an objective criteria. This was something which was held by the Honorable Supreme Court. कौन से कट ऑफ मार्क्स की बात हो रही है फॉर द एग्जामिनेशन ऑफ डिपार्टमेंटल सिलेक्शन कमिटी. उसमें क्वालिफाइंग मार्क्स फॉर द पोस्ट ऑफ सुपरवाइजर इंस्ट्रक्टर क्लास 3 की बात चल रही है. उसके जो क्वालिफाइंग मार्क्स है उसको रिड्यूस कर दिया गया था, एंड जो रिडक्शन किया गया है दैट इज एक्चुअली डन लेटर ऑन. उससे क्या हुआ है, because of that the candidates that have been selected for the post, they are coming up by some extraneous reasons and accommodating otherwise ineligible candidates. So this was challenged by way of an SLB before the Honorable Supreme Court of India. Marks that are to be eligible for the post, they cannot be reduced later on unless and until there is a sound reason which is required, which is sufficient enough. You cannot do such kind of things. This was held by the Supreme Court. Order of the Division Bench of High Court of Gujarat was actually upholding that thing. So that order or decision. So it was actually not sustaining in law. This was held by Honorable Supreme Court, and court has exercised its power under Article 142 of the Constitution to do complete justice in this particular case. That ऐसे provisions arbitrariness को promote करते हैं. This was not supported by the Honorable Supreme Court. Second judgment, Yogesh Upadhyay and others versus Ajanta Limited. ये जो केस लॉ है ये भी काफ़ी लैंडमार्क है. 21st of February को आया है. ये एक्चुअली ट्रांसफर पेटिशंस रिलेटेड है. 6 complaints are there relating to the check bounce cases that have been in question in this particular case. And ये ट्रांसफर पेटिशन जो फाइल हुआ है दैट इज टू ट्राई टू ऑल टुगेदर द 6 कंप्लेंट्स. इसमें से 2 कंप्लेंट्स एक्चुअली नागपुर के कोर्ट में चल रहे हैं. सो द पेटिशनर हैज़ मेड अ कंप्लेंट दैट 4 कंप्लेंट्स ऑलरेडी द्वारका कोर्ट दिल्ली में चल रहे हैं. बाकी के 2 कंप्लेंट्स भी आप ट्रांसफ़र कर दो. And the question of law that was pertaining to the conflict that arose in this particular case was that Section 142 of NI Act and Section 406 of CRPC, is there a conflict between both and which will prevail over which law? So the court held that notwithstanding the non-obstain clause in Section 142 clause 1 of the Negotiable Instruments Act, power of this court to transfer criminal cases under Section 406 of CRPC remains intact in relation to offences relating to Negotiable Instruments Act relating to check bounce cases as well. So if it is found expedient for the ends of justice, the court can transfer cases. And in this particular case, it was advised that to have a common adjudication, it is actually required that we transfer all the cases to New Delhi Dwarka Court for the possibility of contradictory findings be ruled out. This was one of the reason which was held by court, and court held that 406 of CRPC will not get affected by Section 142 of check bounce, that is NI Act of 1881. So this is a landmark judgment. Next, the state of Gujarat and others versus HB Kapadia Education Trust and others. In this case, the Honorable Supreme Court has observed that the division bench of Gujarat High Court, that order has been set aside, observing that and a violation of Article 30 of the Constitution has been carried out. Reason being that there was a principal who was not granted extension due to his retirement, and due to that he was stopped his grants in aid. So that decision was challenged before the Gujarat High Court division bench, and the court then held, the Supreme Court held that the state of Uttar Pradesh, in this particular judgment, a citation that was taken was relating to state of Uttar Pradesh and others versus Principal Abhay Nandan Inter College and others, observed what that particular instance has been taken as a reference over here. When it comes to aided institutions, there cannot be any difference between minority and non-minority institutions. So Article 30 of Constitution is subjected to its own restrictions, and those restrictions are reasonable in nature. Protection cannot be expanded into a better right than one which a non-minority institution enjoys. So the law has become quite settled on this issue, and that does not require any kind of elaboration. So upholding this, the Supreme Court has held that we have no hesitation in reiterating this principle here also, and the institution that is receiving aid is bound by the conditions imposed and is expected to comply with it. So the Supreme Court has held in favor of the principle. It has held in favor of the principle, and the grants in aid should have been given to him. As a judgment, aye. Sanvarlal Agrawal and others versus Ashok Kothari and others. Another Supreme Court judgment which has allowed a petition against the order of High Court of Bombay. This is on the point of interpretation of decree. Execution of decree पर है ये judgment, काफ़ी important है. Execution of decree के वक्त कोर्ट का जो executing court का जो role है वो कैसा होता है regarding to interpretation of the decree. So it was held that the court cannot go behind the decree. Whatever principle is there in the decree, court has to stick to it. Law says that it is undeniable that an executing court can construe if a decree is ambiguous, but it cannot go beyond that. In the facts of the case, this cannot result in additions. Court cannot make its own additions. This was held by Honorable Supreme Court in this particular case. And the single judge and division judge bench of the High Court of Bombay has actually erred over here, interpreted the appellant's silence amounting to acquiescence in this particular case. Appellants were silent on some point. So court has actually added its own interpretation by assuming that his silence is acquiescence, and that is relating to the loan amount. So this is actually not a just expansion of the decree was held by the Honorable Supreme Court in this particular case. Very, very important judgment this is, especially from the point of view of execution, practicing lawyers के लिए and judiciary के लिए जो aspirants prepare कर रहे हैं उनके लिए भी बहुत ये judgment काफ़ी important and landmark है. The Directorate of Enforcement versus M. Gopal Reddy and another. In this petition, the court has set aside the order of High Court of Telangana and Hyderabad, and an anticipatory bail that has been granted to the accused for an economic offense has actually been set aside by the Supreme Court in this particular judgment. ये judgment मैंने इसलिए लिया है because I wanted to show you that in this particular case what court has held about bail applications, how they need to be treated in anticipatory bail, that is section 438 of CRPC. So the court has said that in case of economic offenses, it is going to actually impact the society. So court must be slow in exercising the discretion under section 438 of CRPC. Another very important judgment. State of Haryana and others versus Niranjan Singh and others. In this court, the Honorable Supreme Court has set aside the judgment and order of High Court of Punjab and Haryana. It is relating to land acquisition. Actually, the land has been released by the state. So the court has held that the land that was acquired for residential and commercial development purposes could not have been utilized for some public purposes and development of area by the government by exercising powers arbitrarily in favoritism. The state government is guardian of public interest. Public interest should actually prevail. So rather than releasing that land at a very initial stage under the influence, the state should actually take care that this should not happen in the future. Lands that are acquired for the purposes should be utilized for those purposes which are actually public in nature. उसके लिए अगर आपने land acquire करना है तो you have to use it for that purpose. You cannot release it at such an instance किसी के influence में आके. And otherwise what will happen? The object and purpose of acquisition of land will actually be frustrated. तो ये लैंड एक्विजिशन के इंटरप्रिटेशन में काफ़ी इंपॉर्टेंट लैंडमार्क जजमेंट है जो रिसेंटली पास हुआ है. S. Murali Sundaram versus Jyotibai Kanan and others. In this particular case, the Honorable Supreme Court has talked about the review jurisdiction. In this case, judgment of High Court of Madras, Madurai bench, which is deciding a review petition, has been actually set aside. Court has said that the High Court of Madras has exceeded its power of review. Section 114 of CRPC के हिसाब से जो आपके power है, that is the High Court has exceeded its jurisdiction and exercised a jurisdiction which is not vested in it under Order 47 Rule 1 read with Section 114 of CPC. So review jurisdiction limited होता है, but अगर उसको exceed करके आप decision को altogether substitute करते हो, then that is not a review jurisdiction. It is going into the nature of appeal jurisdiction, appellate jurisdiction. तो वो आप exercise नहीं कर सकते. एक रिट पिटिशन का डिसीजन का व्यू आप ऑल टुगेदर चेंज कर देते हो रिव्यू पिटिशन में, दैट इज नॉट एज पर लॉ एंड इट इज एक्सीडिंग jurisdiction ऑफ रिव्यू. दिस वाज हेल्ड बाय सुप्रीम कोर्ट. Roopwanti versus State of Haryana and others. In this particular case, the court has dismissed the appeal that was filed against the judgment and order of acquittal passed by High Court of Punjab and Haryana. And it was held that the order of acquittal will prevail actually. The Honorable Supreme Court has held a landmark judgment that is relating to Mrinal Das and others versus State of Tripura. It has been taken as a reference that an order of acquittal is to be interfered with only when there are certain compelling and substantial reasons. तो ही acquittal में interfere किया जाएगा. If the order is clearly unreasonable, it is a compelling reason for interference. But अगर ऐसा कुछ नहीं है, so उसमें interference नहीं किया जा सकता. That acquittal judgment has been upheld in this particular case, and it is a very important judgment in establishing law relating to acquittal in, that is the criminal law has been set in this particular case. Sirajuddin versus Zeenat and others. This is a case relating to another very important and interesting point relating to evidence has been come up in this judgment. I'm telling you, very interesting judgments have come up this 15 days. स्पेशली जो जुडिशरी के लिए प्रिपेयर कर रहे हैं उनके लिए ये सारे जजमेंट्स काफ़ी इंपॉर्टेंट है. बी CPC, बी क्रिमिनल लॉ, एविडेंस, ये सारे जजमेंट्स आपके लिए काफ़ी लैंडमार्क हैं, काफ़ी इंपॉर्टेंट है. Appeal against the judgment and order of High Court of Ernakulam has come up in this particular case. It is a suit for cancellation of sale deed and prohibitory injunction, which was actually dismissed by the court, and directions were given to the trial court to decide the suit afresh, यानी कि de novo trial करने के लिए. ट्रायल को आप शुरू से नए सिरे से शुरू करो, ऐसे डायरेक्शंस दिए गए थे ट्रायल कोर्ट को रिलेटिंग टू द सूट ऑफ cancellation of sale deed and prohibitory injunction. So, but obviously, petitioner has come to the Honorable Supreme Court against the judgment of High Court as well. And actually, in this particular case, the court has held that suit filed by the respondent, trial court has indeed returned its findings on the basis of evidence that is recorded. So the evidence that was recorded, if it is considered that that evidence is actually not sufficient, then on relying on those mere preponderance of probabilities, evidence that is not on record, it cannot be treated as insufficient. Provision कौन सा रेफर किया गया है यहाँ पे? प्रोविजन सेक्शन 114 ऑफ द एविडेंस एक्ट, उसका क्लॉज जी रेफर किया गया है, दैट इफ अ पर्टिकुलर एविडेंस विच ऑट टू हैव बीन एड्यूस्ड बट इट हैज नॉट बीन एड्यूस्ड, देन ऑटोमेटिकली अ प्रिजम्पशन विल लाई दैट इफ इट वुड हैव बीन एड्यूस्ड इट वुड हैव गॉन अगेंस्ट द मेकर, इसीलिए उसे जानबूझ के एड्यूस नहीं किया गया है. This is what is the direct provision given in Indian Evidence Act section 114 clause G. So उसको consider करते हुए court ने कहा है that the appellate court cannot adopt any soft course for remanding this matter. Remanding the matter back is not the right remedy in this particular case. So the remand of suit for trial de novo was considered as unjust and will not actually stand. ऐसा होल्ड किया गया, ऐसा हेल्ड किया है सुप्रीम कोर्ट ने. शारदा कंस्ट्रक्शन वर्सेस भूपेंद्र प्रमाणिक. This is a judgment of the Calcutta High Court, an interesting judgment by the Calcutta High Court. It is relating to section 11 of the Arbitration and Conciliation Act, under which an arbitrator is appointed. तो ये जो powers हैं of appointment of arbitrator, क्या ये चैलेंज हो सकते हैं अंडर रिव्यू? दिस इज व्हाट इज द क्वेश्चन ऑफ लॉ इन्वॉल्व्ड ओवर हियर, एंड इट वाज हेल्ड दैट द मेन पॉइंट, आई विल लेट यू नो, ये केस लॉ है जो रेफर किया गया है, इसको आप अच्छे से डिटेल में पढ़ सकते हैं. द मेन पॉइंट दैट वाज द कंक्लूजन इज दैट द कोर्ट हेल्ड दैट द पावर ऑफ रिव्यू इज अ क्रिएचर ऑफ स्टैट्यूट, इट कैन नॉट बी जस्ट डायरेक्टली इम्प्लाइड, and Supreme Court, the Honorable Supreme Court is having inherent powers of review under Article 137 of the Constitution, but it is not so for the High Courts. So keeping this thing in mind, High Courts are not having any kind of such power. So Section 11 of the Act, against that, a review in the instant case is not maintainable. This was held by the Calcutta High Court. Devendra Kumar and others versus State, NCT of Delhi and others. In this particular judgment, the Delhi High Court has talked about the caretakers and bearers of the mandir who were actually approaching this court against of course the road widening, the encroachment that they have caused on the road. So now the question that was involved simple was that public right to way versus religious beliefs and practices, which will be kept in mind, which will be held. So the court has taken the view that the larger public interest will outweigh the concerns that are raised by places of worship, that is mandir or masjid. कोई भी religious denomination हो, that over that or the larger public interest will actually outweigh it. There is no gainsaying that places of worship cannot be encroaching public land and hindering developmental activities meant for larger segment of the public. Because larger segment of the public कहाँ पे है? Using the roads, for example, that is having a larger segment of public interest involved. So that will always prevail. This was held in this particular case. Sandeep Kudale versus State of Maharashtra. This was a judgment passed by Honorable High Court of Bombay. This is relating to quashing of FIR, section 482 of CRPC. An FIR was filed very hastily against Sandeep Kudale, and even a fine was imposed on him of 25,000 costs actually, which was to be recovered from what happened in this particular case. 25,000 costs, sorry, not fine. The FIR was quashed and court has imposed this particular fine cost of rupees 25,000 on the police officer for wrongful arrest as a punishment for wrongful arrest to curtail the arbitrary hasty and wrongful arrests. Basically, this move has been initiated by the Bombay High Court. Court held that the offence is made out or not, an arrest visits serious consequences on the person who is arrested. So the offences alleged have to be serious in nature when the police is actually trying to arrest that person, because it is having serious repercussions on the person's life, his family's life. So all these things, his reputation, his career, everything has to be considered, and then only a decision as to an arrest has to be made out. So this is a very, very important point that has been discussed in this particular case by the Honorable High Court of Bombay. And prima facie, it has appears to us that the petitioner was slapped with the said sections without any application of mind. There was no application of mind by the police officers. That's why the cost of 25,000 has to be taken from the salary of police officers. Such kind of judgment has come out, and the FIR has also been quashed. Court has also upheld the importance of fundamental freedom under Article 19(1)(a) of the Constitution. Basically, FIR जो हुआ है वो fundamental freedom of speech and expression exercise करते हुए file हुआ है. The person who has been charged for offences under this particular FIR, Sandeep Kodale, has actually posted some video on the social media. So that is what is under challenge, and that was actually leading to his arrest. So the court has held in favor of the petitioner. FIR has been caused because it was not held. That is something very much objectionable. It is a part of his fundamental freedom of speech and expression. So court has said that a balance has to be maintained, and arbitrary arrests को कर्ब करने की importance इस particular judgment में भी जताई गई है. So this was all that I had from my side from all the landmark judgments that have come up till now. And for all such kind of updates, don't forget to subscribe to our YouTube channel. And for all the examinations that you are preparing, prepare with iExamBee 50% faster. Thank you so much, everybody. Have a good day.